just mentioned the next word that I want to ask, executor.
The executor is basically the person who manages the estate. And yeah, it basically just means that's the person who has the role of dealing with the estate. And that person can be the beneficiary. For example, it's very common for spouses. If you're in a married relationship but without children, you can say, I want my spouse, if I pass away, my spouse manages the estate and they get everything, right? So it just makes things easy. You know, they can take over the home and the mortgage payments. They can take over the bills and whatever else is going on. Very quick and seamless transition. The executor can be paid compensation. It really just depends on the relationship between the parties. You know, for example, if a spouse is the executor, usually there isn't going to be a compensation named, right? It's just expected they'll just deal with the estate. But there could be a situation where somebody is leaving a company to be the executor because they have, for example, a single parent with young children, and they want to make sure that some money is reserved in a proper trust account and distributed to the children over the years. So in that situation, the executor is probably going to be compensated, right, for the time and effort of managing that estate on the individual's behalf. But that's basically what it is. It's basically a person who has the role of dealing with the estate and following the wishes of what's in the will, right? So they look at the will, they say, okay, you know, this person gets X dollars, and they actually go to the bank and get the check done and send it out, right? To make sure everything is followed in accordance with what the person wanted.
Probate. What is probate?
Yeah, so the probate process is basically like a formal approval of the will, I guess. I'm kind of trying to take it out of the legal terminology, right, into the real world. Basically, the probate process, you go into the court system and the courts approve the will, or they don't in rare circumstances. And basically means they've looked over the will and they say, okay, this is a valid will. Person had capacity when they signed the will. The execution was correct, right? The witnesses and the signatures are all there. The terms of the will are all properly drafted, that we can now go ahead and deal with the estate and actually administer to the estate, right? Giving out the proceeds and the distributions. So the probate process is not always necessary, right? For example, if it's a very simple will just between spouses, most likely you don't need to go through probate. You can just go to the bank and basically say, you know, my spouse passed away, here's the will and testamentary documents, and they'll just work with you directly to empty out the accounts or whatever needs to be done. If it's a more complex matter, for example, I've dealt with this when, you know, you have a will with codicils. A codicil is basically like an addendum, like an addition to the will. It's a one-page document saying, you know, I'm changing section 6D used to say this, I'm changing it to, you know, it used to be $40,000, I'm changing it to $50,000, something like that, like a small addition or change. So if your codicil, maybe it wasn't properly signed, right? It wasn't, you know, you have one signature, but there were no witnesses or something like that. In that case, a bank or a financial institution, insurance company, they may ask for you to take the will through probate. So they can say, this is too complex, we're not sure what's going on here, we'd rather have the court look at the will, right? So the probate process is a good process for situations where it's not at a level of a will challenge, right? It's not, you know, there's such severe problems that we can't follow the will at all, but it's that we need a professional judge's set of eyes to look this over, to confirm everything's okay, give the stamp of approval, and then allow the parties, you know, to feel a little more comfort as they work through that will. The big caveat with probate is once you go through the probate process, you have to pay estate administration tax, right? There's tax on the value of the estate. So some people will avoid probate as a way to avoid that additional tax burden. The tax burden is on the estate, so it's not like as a family member, you know, you'd go to court and they'd say, oh, now you have to pay thousands of dollars. It's not like that, right? It would be the estate itself has to pay that tax burden. But obviously that would lessen the amount that could go to the beneficiaries So generally, people will try to avoid probate if they can. Also takes some time, right? There's some time and cost involved. So, it's a process that is generally used when needed, right? When there's a company or an entity or a financial institution that's sort of saying, we've looked at the will and we'd prefer that this goes through the probate, the formalization process.
So Sam, every so often I come across the term joint survivorship. What exactly does that mean?
Yeah, so this is a term that basically usually applies for real property, right? Like
Yeah.
your home, your real estate.
Yeah.
And there's two ways that property can be held. It can be held as a joint tenancy, or sorry, how property can be held when there's multiple people, right, listed on the
Right.
property. It can be held as a joint tenancy or a tenancy in common. If it's in a joint tenancy, then there's what's called the joint survivorship, right? Which is a right that passes to either party. So keep it simple, and we'll just say there's two people involved. There's John and Jane own the house. If John passes away and the house is owned as a joint tenancy, Jane inherits 100% of the house, inherits it outright. So that's joint survivorship. Basically means whoever the survivor is, they just get the whole thing. The other side of that is tenancy in common. So if John and Jane own the house in common, it means that if John passes away, Jane owns 50% of the house still, 50. John's 50% goes into John's estate, becomes part of his estate, and can be passed on to children, maybe back to Jane, right back to the spouse if he wants, maybe to a third party, who knows. So obviously that can cause some problems in the estate planning context, right? You don't want to have a situation where one person's in the house and part of the house is owned by some other third party, right? Can make things a little complicated, but it's possible. But generally what you'll see is a joint survivorship in that spousal relationship, right? Because the expectation is usually the house is going to pass on anyway back to the other spouse, the surviving spouse.
Okay, great. Last word. What is the word trust? What is in the estate planning context? What does the word trust mean?
It's actually several different trusts that can be set up for estate planning specifically. Typically, a testamentary trust is what you're talking about in the estate planning context. And the testamentary trust is basically a trust in the estate that gives usually money, right? Usually proceeds over time to the beneficiary. So holding something in trust basically means that one party is holding it for the benefit of another. So if I pass away and I have my will with a testamentary trust to my child, for example, and the will assets are basically going to be held by the trustee, by the executor in an account, right, in a bank account, and then distributed over time to my child or whoever is named as the beneficiary, right, under that trust. And in a testamentary trust, usually it's set up by age. It's usually set up that at age 18, they get 50% of the estate. And then at age 25, they get another 25%. And at age 30, they get the last 25%. Those numbers are just hypothetical, but obviously those percentages and ages can change. But that's usually how it's done in terms of the setup, right? The idea is especially for a minor beneficiary, right? Someone who's just a child. Let's say your beneficiary is 8 years old at the time you pass. You don't want that beneficiary inheriting millions of dollars that just need to be taken care of for them anyway. So the idea is you set up a trust, the money stays in the estate, stays in the estate's bank account, and gradually gets dispersed over time. Usually 18 and 25 are seen as pretty standard years, 18 being when university starts, right? And the child hits the age of majority, so is actually able to independently make the financial decisions. 25 post-university as they're starting, life and family and all those things, right? So you can set it up any number of ways, but usually it's done along certain age brackets to make sure that the child is still getting some value, right, as they progress through their young adult life.